introduce the last speaker for this first session, Mr. Philippos Aristotelos. Should I say it's your birthday or should I say that it's your birthday? But happy birthday anyway from all of us. Legal business strategist, author and speaker, who will speak about marketing and law firms.
Okay, good afternoon. I will talk about the good stuff, lawyers and ethics. How courageous of mine. We have quite a few things to cover, so I will delve right into this. I would like you to imagine the following story, okay? This is John. He recently had a car accident. He's in the private hospital in Nicosia, and he's concerned about the medical bills which are piling up, and he's thinking of hiring a lawyer. While he's pondering on these thoughts, you make a triumphant appearance. You approach him, and by the way, your friend, a nurse, told you about John, and you convince him that you will fight for him and you will help him recover. Busted. Chapter 1 of Lawyers' Ethics. Agra peladon, client solicitation. Now let's imagine the same story with a slight different twist. Okay, scenario B. John is in the hospital, he had a car accident, he's concerned with the medical bills, and while he's pondering on whether to hire a lawyer, he grabs his mobile phone, he begins playing with it, he searches for some legal stuff, and your banner pops up on his screen. You're ready to help him. He clicks on the banner, he contacts you, he hires you. Now, is this client solicitation? Is this just an advertisement? Is it both? And why should you care? Welcome to the world of digital marketing and ethics. Quickly, over 38% of clients start looking for a lawyer online, personal injury client, a lawyer, criminal lawyer, you name it. But most importantly, over 96% of people who look for legal advice start online by using a search engine. So we live in the DIY age, especially with millennials. So the key here is to be able to position ourselves where there is attention. That's why it's very important to have an effective digital marketing strategy, which is nothing more than the process of promoting your firm online so as to position yourself before the eyes of your potential customers, right? Now, I will not be talking about the digital marketing strategies and the things that I'm sure your digital marketing agents are doing for you. But my focus, as you have seen, will be on the interplay between digital marketing and ethics, the good stuff, right? And why is this even a topic worthy of delivering a talk over? Because the legal profession is a profession of high integrity and honor. The lawyer is not like the common merchant who can apply hard-selling skills so as to sell his services and generate work. There is a delicacy involved. That's why the lawyers have to comply with professional ethics so as to avoid eroding the public trust to their profession. Now, your starting point, I'm talking about Cyprus now, okay, is the code of conduct, that lovely blue book we all received when we did our bar exams. There are many paragraphs that are relevant to marketing in that code, mind you, but our starting point and focus is the solicitation of clients, paragraph 17, and publicity, paragraph 19. Everything else pops up incidentally, okay? So let's see quickly about solicitation, the positive statement that lawyers are allowed, of course, to develop their practice, subject to the code of conduct and the high standards of the legal profession. Then lawyers are not allowed to engage in client solicitation, agra peladon, as we know. And finally, and relevantly, clients are not allowed to engage agents, brokers, δικολάβους, so as to refer work to them, as the nurse in the beginning of the scenario I mentioned, and many others. That's all well, but we don't have a definition. Takis Iliadis, in his book, Code of Conduct, he provides an interesting one. He says that solicitation is the unsolicited offering of legal services, And particularly, pay attention, the act of approaching, okay, a client who is unknown to the lawyer, that's solicitation. Let's see another interesting angle, the same book, the persistent presence in the court's corridors so as to approach unknown clients is also solicitation. Now, it could be the courts, the hospital, it could be the prison, whatever. It's the same philosophy that if you are persistently present somewhere so as to hunt prospects, you are violating the rule, right? And the last point, a case that is widely reported in all the books in Cyprus on code of conduct and ethics. It's a case involving a lawyer who wrote a letter in 1993, before the internet boom, to the Horse Riding Association of Limassol, telling them that, you know, I can represent you for free, knowing that they were represented already by another lawyer, right? So he got reported, he got fined, he appealed, he lost the appeal, and that's the end of the story. So pay some attention on the red phrases, and these, of course, have nothing to do with digital, right? These were before the internet boom. Let's see if some of these key sort of phrases in the decisions and the text can apply in the digital world. The act of approaching, we've seen, an unknown person. Okay, we can send a letter, 1993, we can meet them in the corridors, but what if we send them a Facebook message? They are unknown. What if we send them a newsletter? What if we send them, listen to this, a message on Mondag because they read our article to see if they want information? What about our websites? What if we send them a Facebook request knowing that they are represented? Where do you draw the line? We have millions of interactions today online, and where do we draw the line so as to know whether we violate the rule or not? And then let's move to the corridor point, the persistent presence in the court's corridors or hospitals or whatever. What if we have a persistent digital presence in the court, in the hospital, in the prison, in the port? We've seen the banners. We can target with surgical precision a building and bombard everyone with ads. A hospital, a conference like this one. So where do we draw the line? Are we approaching people in the sense that we are soliciting work for them? What's the answer? As you may have guessed, in Cyprus, we have no guidelines on this. Not only in Cyprus, we don't even have guidelines on a European level, on the level of the Council of the European Law Societies, the CCB. In order to find some light, we should check in the UK and the US. The new code of conduct of solicitors in the UK, I believe it's coming into force in November. There was an overhaul of the old ones. First of all, includes within the definition of publicity, websites, advertisements, and many other things. So it is the chapter of online communications fall within the rules of publicity, okay? Not so much solicitation. And the American Bar Association, that is really attuned with the digital world, and many states in the US follow the model of the ABA, provide the following. Communication, 7.3, communication is not solicitation, okay? If it is addressed to the general public. So your social media posts, your website, and generally your online activity is not solicitation if not addressed to the public. And the second really interesting point in the ABA's rules that touches on how you send a message, how you approach someone, and whether your approach itself amounts to a solicitation is then the reference to real-time communication. The ABA, and this is followed by many states in the US, say that we are bombarded every day with emails, newsletters, social media posts, messages for services. We have to draw a line. It's not the same like 1993. You will send a letter and people will hold it and sleep over it. Now, to be able to convince someone to hire you, you need real-time communication, because if you send a LinkedIn message, somebody can ignore it. A newsletter, they can unsubscribe. If you send something on Facebook, they can block you, right? So the freedom of choice of the consumer is not eroded if there is no real-time communication. This is what the ABA says, right? But if there is real-time communication, you talk to someone on a Skype call, on a video chat, And essentially, you don't allow them time to reflect on what you tell them. Because you are a lawyer and you have persuasive skills, right? The APA says that, yes, then there is a risk of solicitation because you deprive them of the time to reflect, right? This is what the APA and the UK regulations on ethics say. We don't know if Cyprus and when the European Council will issue guidelines. We'll be following up on that. But I've saved the best thing for last. In the Horse Riding Association case, you may have seen that the lawyer offered his services for free, where this is a cheap shot that will get the lawyer reported. Because you know that who is going to report you? Your competitor. So whether you send a message by email, by LinkedIn, with a pigeon, okay, with a messenger or not, the point is that unless you offend someone, a colleague, you will not be reported and tried by a committee of lawyers, right? So until we find out what is going on, I think that this last point is sort of the key to the whole discussion regarding the solicitation. Publicity, very quickly, paragraph 19. There is a confusion on this point, and some books still refer to the previous section of the law. I only need to mention that in 2013, there was an overhaul of the publicity clause. We copied basically the paragraph 2.6 of the European Council of Law Societies formulation, and this is exactly it, the CCP BE1. Very quickly, you are allowed to inform the public about your services, provided that the communication is accurate. Is it working? Accuracy, it is not misleading, you comply with confidentiality, and you comply with other core values of the profession. Dignity, not eroding the trust of the legal profession, not over-boasting, and the core values that we all know, presumably we all know. And electronic commercial communication, of course, is included. Borrowing, again, from the solicitor's regulations, publicity includes, as we've seen before, all kinds of communications, online, offline, websites, social media, directories, right? And let's see now what is the key criterion that I see. In case anyone is going to be caught by the publicity rules, whether on their website, social media activity, or you name it, most likely it's going to be on the misleading ground. And let's see an example of a website, all right? Now let's pretend for a moment that this is Cyprus law firm website. And we'll see a couple of points, and we will see whether any of the representations there, as we've said, the website and everything in it constitutes publicity, right? So it has to comply with the rules. Let's take the central one. Number one, injury law firm. And I want to be specific. Let's refer to references to specialization and expertise. It's a big fuss. Last February, the Bar Association issued an announcement. The point that lawyers are not allowed to refer and to allege that they are specialists or experts is a simple one. The advocate's law does not provide anything for specialization. It only provides what you need so as to be licensed as an advocate. Only one type of advocate. In Germany, for example, there are specific provisions saying what you should do to be able to say you are specialized. Okay? If you are a labor law lawyer and you handle 100 cases in labor law, you can say so. If you are a family law lawyer and you handle 120 cases, you can say you are a family law specialist. And traffic accidents, 160. That's in Germany. So there is a procedure and there is a framework within which you can actually rely. So it's better not to refer to being a specialist or as being an expert, even though you may be, and to refer to your experience as something more subtle. No win, no fee. Does it ring any bell? The laws against chamberty, some people say contingency fees are prohibited, others say they are outdated. Whatever the case, since it's a controversial issue, if we are saying that we offer no win, no fee, it means people will believe us. So I say we are misleading them. That's my argument. And the most interesting one, 95% success rate, especially in litigation. 95% success rate. Let me ask you a few questions, right? How do you measure success? Do you include only first instance? Do you include appeals? What if the plaintiff withdraws a case? What if the judge dismisses a case for not pursuing? What methodology have you used? Can you objectively verify your success rate in case you are challenged? Is it accurate? Is it misleading? Does it comply with other core values, like the duty of collegiality, paragraph 35? It's a big discussion, but my view is that success rates are a bit delicate, right? So you can see that on a website, there can be communications and information that some people can say are not entirely accurate. Now, social media, very quickly, as we've seen, any activity amounts to publicity, even though it has a casual look. It has to be accurate, it should not be misleading. Core values of the profession again. Social media accounts cannot guarantee privacy. Look at the Facebook scandals. Look at, there was recently a scandal that Facebook transcribes all voice notes and vocal discussions. So if a client would like to open a discussion online, it's safer to invite him to the firm or grab the phone call. And relevantly, retainers can also arise by implication, through an innocent discussion online. You can answer a question on a legal point, and without knowing it, a lawyer-attorney relationship can arise with all the implications. So better invite people off social media and for many other reasons, and save everything for the first appointment or a call, right? There are risks. It's a minefield. Lastly, it goes back to the previous discussions on the future of law. Online matching platforms, these haven't come to Cyprus yet, but they are really hot in the US and the UK, and they've also, some of the companies are active in Europe as well. What these do basically is that they match clients and lawyers, and they're like the Amazon or the eBay of legal services. And basically, once there is a matching of a lawyer with a client, the platform then charges some sort of marketing fee at the end of the transaction, which is usually commensurate with the value of services. Although some companies like Evo, for example, have been banned in the US because it was deemed to be violating the fee referral provisions, the equivalent in the US. Here we have paragraphs 28 and 37, which say that you cannot share referral fees with a non-lawyer, right? Other points that may arise with these platforms, the independence, that the lawyer has to be independent. The platform has wide powers to interfere if there are customer service complaints between the lawyer and the client. So if there are problems, then the platform will require information. So the confidentiality is an issue as well. There is interference. Even on AML issues, the lawyer may refuse to serve a client, and he will be penalized in terms of ranking because of these things. So it's a cocktail of challenges, not only regulatory challenges, but also challenges touching on the ethics. Lastly, of course, advertising rules also have to apply on platforms. And to close up, that's for the online platforms, which, as I have said, they are becoming really hot, especially in Europe now as well. Lastly, wrapping up, law is lit. Assume that your digital marketing agent knows nothing about the law, okay? And I'm not trying to sound patronizing, but it's like, I don't handle my websites. It's my digital marketing that handles what's on my website for the leads, for the publicity. It's your reputation and license on the line, not your digital marketing agents. Second, everyone does it. No one cares about ethics. The question is, would you like to be like everyone? And lastly, I haven't even touched on data protection. We'll take the whole day. GDPR touches on everything that we have seen. I hope you have gained some value, and thank you very much.